A debt is like most legal matters and is subjected to a state's or territory's statute of limitations, whereby if a creditor has not been able to recover the debt within those states or territories' timeline, the debtor is not legally obliged to pay the debt. With this in mind, debt collection for any business should be a priority. Failure to collect debts impacts cash flow and can cause financial troubles. For the purpose of this video and keeping it general to Australia, we will use a simple contract debt as the focus for this information. What is Australia's statute of limitations for debts? If you want to know when is a debt written off, in Australia the statute of limitation for debt varies by the type of debt and the jurisdiction of which the debt is held. With the only exception being the Northern Territory, where the statute of limitations is 3 years, all other states in Australia are subject to a 6-year statute of limitations rule for a simple contract debt. Equally important to understanding your state or territory statute of limitations, is that it is not the deadline for recovering the debt but the deadline for filing a relevant claim within the courts. If you have received a judgment from the courts in your favour to recover the debt, this judgment may influence the statute of limitations through most of Australia to a 12-year statute of limitations. What does a statute-barred debt mean? A creditor has the right to sue a debtor for the recovery of the unpaid debt during the limitation period. However, if the limitation period expires, the debt then becomes statute-barred. This would mean the creditor is no longer able to take legal action towards recovering the debt, and the debtor would have an absolute defense. Therefore, even if the creditor files a claim, it would not be legally enforceable. When is the start of the limitation period? Simply put, the start of the limitation period is when the creditor legally has the right to take action against the debtor to recover the debt. The limitation period, more often than not, begins at the time the debt is due or when the terms of the agreement have not been met by the debtor. The actual date this may start will vary depending on a number of factors such as the terms of the contract, which jurisdiction, and the classification of the debt. It is essential to consult with a professional debt recovery specialist if you believe as a creditor you have a statute-barred debt. Is a statute-barred debt collectible? While the debt still exists in all states and territories, except in New South Wales where the debt is cancelled at the expiry of the statute of limitations, it is unenforceable. You may still try to recover the debt, but you would need to exercise caution and only ask for payment. You are not able to threaten any form of legal action or mislead the debtor by making them believe they are under any threat of legal action to pay. From a legal perspective, seeking to recover a statute-barred debt is a perilous situation. Should you violate the law in process of attempting to collect on the debt, you might find it is you who is facing legal action. How long before a debt becomes uncollectible in Australia? In Australia, a debt becomes uncollectible after the statute of limitations has expired. The statute of limitations is the time limit within which a creditor can take legal action to recover a debt. The statute of limitations for unsecured debts, such as credit card debt, personal loans, and unpaid invoices, is 6 years in all states and territories except the Northern Territory, where it is 3 years. Once the statute of limitations has expired, the debt is considered statute-barred. This means that the creditor cannot take legal action to recover the debt, and the debtor does not have to pay it by threat of legal action. However, there are some exceptions to this rule. For example, a creditor may still be able to recover a statute-barred debt if 1. The debtor has acknowledged the debt in writing within the 6-year period. 2. The debtor has made a payment toward the debt. 3. The creditor has a court judgment against the debtor. 4. The debt is secured by collateral, such as a mortgage. If you are unsure whether a debt is statute-barred, you should speak to a debt collector or lawyer. How long until a bad debt is written off? There is no set time frame for when a bad debt is written off. It depends on a number of factors, including 1. The company's internal policies and procedures. 2. The type of debt. 3. The debtor's financial situation. 4. The likelihood of collecting the debt. Some companies may write off bad debts after a certain number of days, such as 90 or 120 days. Other companies may wait longer, depending on the factors listed above. Ultimately, the decision of when to write off a bad debt is up to the individual company. Here are some general guidelines for when a company may write off a bad debt. 1. The debt has been unpaid for more than 120 days. 2. The debtor has filed for bankruptcy or insolvency. 3. The debtor has disappeared or cannot be contacted. 4. The debtor has refused to make any payments or negotiate a payment plan. 5. The company has determined that the debt is unlikely to be collected. If you are a creditor and you are considering writing off a bad debt, you should speak to a debt collector to see if they can bring in your aged receivables. Thank you for watching. Don't forget to subscribe to our channel to stay up to date with our latest content. If you have any questions, leave them in the comments below.